All right. Hello, everybody. A very good evening to all of you, ladies and gentlemen, who are joining us online this evening. We resume the first webinar series after the August court vacation today. I am privileged to welcome all of you, both panelists and members of the audience, joining from different parts of the island for the 55th webinar of the English webinar series, which is organized by the Seminars Committee of the Bar Association of Sri Lanka. These webinars have also progressed to 4 series weekly in Sinhala, Tamil, and English, and on personal and professional development, and are available online for viewing at any time via the BASL YouTube channel. Since most of us are mostly at home these days and not so much in court or chambers or at your workplace, these days would be a great time for you to check them out and make use of the BASL's continuous professional development endeavor. So today's webinar, the 55th webinar, is titled COVID-19 Temporary Provisions of the Law. COVID-19 Temporary Provisions Law. It undoubtedly is a timely topic and will definitely be of use to all members of the legal fraternity. To enlighten you all on the laws and the provisions related to the COVID-19 pandemic in Sri Lanka, we have a panel of experts with us who I would like to welcome on board and introduce now. First, let me welcome on board Mr. Ikram Mohammed, President's Counsel. Mr. Mohammed has been in practice for the past 47 years. He is a past president of the Bar Association of Sri Lanka, a former lecturer in the law faculty and law college Association of Sri Lanka to examine. Next, we have with us Mr. Jeffrey Alagaratnam, President's Counsel. Mr. Alagaratnam counts 40 years in legal practice. He is a past president of the BASL for the years 2015-2016 and 2016-2017. He has an LLB from the University of Colombo and passed Sri Lanka Law College finals with first class honors. He is a director in the Law and Society Trust and a member of the Standing Committee of Legal Studies at the UGC and a member of the Faculty Board of the Faculty of Law. He has examined and lectured at the Faculty of Law of the University of Colombo. Moving on, we also have with us Mr. S.K. Lankatilaka, President's Counsel. Mr. Lankatilaka has over 3 decades of practice and has been the president of the Mount Lavinia Bar Association. His main area of practice is civil law, and he mostly practices in the Colombo district in courts with civil jurisdiction. Let me also introduce to you the panelist and moderator of the day, Mr. Lasitha Kanuvanarachi, Attorney at Law. Mr. Kanuvanarachi is a present executive committee member of the BASL. He is also the chief legal advisor to the Civil Law Reforms Committee of the Ministry of Justice. So that will be your panel for today's webinar. While I welcome all of you for today's session on COVID-19 temporary provisions of the law, I wish our panelists all the very best and the participants a fruitful evening. Over to you, Mr. Kanuvanarachi.
Thank you, Uma, and good evening to everyone. What we have is today for today's webinar. The topic is COVID virus disease 2009 temporary provisions law. The webinar topic says law, but of course now it has become an act. Act number 17 of 2021, and it has been certified on the 23rd of August 2021 by the speaker. Now, before starting the webinar and before going to the eminent panelists, I would like to give a brief introduction about the background to this act, how this act became a law. Now, we all had the first experience of COVID somewhere in March 2020, when the country went down to a 2 months lockdown, and during that period the courts of the country was virtually closed, and all the government institutions and private institutions also were virtually closed. And thereafter, we had a second episode of Corona COVID-19 pandemic in October 2020. And by that time, the BASL, the Bar Association of Sri Lanka, wanted to develop a concept to introduce a law to provide relief to the people aggrieved by the COVID-19 closures, especially with regard to obtain extension of time limits and various other relief. Then at the same time, the Ministry of Justice also wanted to introduce a piece of legislation which would give relief to the people in various aspects which have been disrupted as a result of the COVID-19 pandemic. Then the Law Development Committee headed by Mr. Ikram Mohammed, President's Council, was invited to develop a concept paper, and that committee also comprised of Mr. Jeffrey Alakaratnam, President's Council as well, who is also a panelist today. And thereafter, the committee, I was also involved in the committee, and thereafter the committee developed a concept paper, and it was presented to the Ministry of Justice. That concept paper was had 4 areas. That concept paper covered 4 areas. The first area is the extension of time limits. The second area is leading of evidence by using remote evidence. The third area is the assigning different courthouses, alternative courthouses. If one particular courthouse is closed due to COVID situation, to assign a separate courthouse to carry on the emergency work. And the fourth part is to give relief to the people who have entered into contracts, the people who are unable to perform contracts due to COVID-19 pandemic. That was the fourth chapter or the fourth section. Then when this was presented to the ministry developed a bill based on the concept papers of the BASL. Of course, there was the second part with regard to remote evidence and assigning different courthouses are basically the same as the concept developed by the Bar Association. But the first part, of course, when it comes to extension of time limits, there is a difference. Of course, there were reasons for that difference. But then the fourth part, the contract part was also incorporated into the bill. But when this was presented to the Parliament, some parties went before the Supreme Court and they challenged the bill. Now, as a result of the said challenge, the Supreme Court has given a determination. In the said determination, the Supreme Court held that the part relating to the contracts, giving relief to the contracts, is not, if this part to be passed, the government has to obtain 2/3 majority. That was a dissenting judgment. However, the judgment stated that that part to go ahead, the government needed to obtain 2/3 majority. So thereafter, the government decided not to go ahead with that particular part and went ahead with the other 3 remaining parts of the act. And that is how the COVID-19 Special Provisions Act number 17 of 2021 became a law on 23rd of August 2021. That is the background to this act. And to discuss this act, we have 3 eminent panelists. Mr. Ikram Mohammed, President's Council, who was the head of the Law Development Committee, who initially developed the concept, and Mr. Alakaratnam, who was a member of that panel, and also Mr. Lankatilaka, who is the chairman of the Civil Law Committee of the BASL, who also went through the act and who had suggested many progressive amendments to the act, which ultimately were incorporated by the legal draft. So that is the background. Now, with that background, let me invite Mr. Ikram Mohammed, President's Council, to give a basic introduction to this act, the scope of this act, and the areas covered by this particular act, especially giving special attention to section 1 and 2, which gives the scope of that, and the interpretations in section 8 of that. It's a moment.
Thank you. Thank you very much, Mr. Kanwanaratji, and very good evening to all. The discussion, as Lasita pointed out, is on the recent act, which is called COVID-19 Temporary Provisions Act of 17/2021. This had been passed on the 23rd, and today we are on the 30th. Just it's a like a newly born baby, which is only 5 days old. So we are now trying to consider the act which are not in fact being put into operation and tested by us or by courts. But however, the basic principles are quite clear. And before anything, I must thank the Minister of Justice for having passed this law so promptly, which is an utter need of the day. The COVID-19 pandemic was a severe pandemic, which brought in a lot of changes in our day-to-day life. Our day-to-day life was affected. The institution, the law and order was affected. The institutions responsible for the administration of justice was affected. And all our rights and also obligations were affected. The time period within which actions or applications had to be made had passed. The time period within which certain things had to be complied had passed. Therefore, it has to be considered as to how relief could be given to those people who were affected. It is in the context, as Lasita pointed out quite correctly, the ministry and the Bar Association intervened, and the net result is this act, which is just 5 days old. The authorities, normally our law always provided for time periods for certain actions, applications, and so forth. Similarly, the law provided for time period within which certain statutory obligations or duties had to be performed. As we all know, for example, an action to recover debts on a contract is prescribed by a period within a period of 3 years. A claim for accident damages caused by accident is prescribed within a period of 2 years. So the question did arise in such actions, if such situations, action cannot be instituted in view of the COVID-19, what are we going to do? In order to minimize and to curtail the spread of this pandemic, government was compelled to take actions. There had been isolations, lockdowns, and various other restrictions. Travel restrictions from province to province, as a result of which people could not proceed to courts, lawyers could not proceed to courts on behalf of their clients, judges could not sit as scheduled. So all the rights of the litigants were affected. It is in those circumstances this law was introduced, and the purpose of the law is very clearly stated in the preamble. The preamble says that is a temporary provision is to make provision in relation to situation where persons were unable to perform certain actions required by law to be performed within the prescribed time. Periods due to COVID. To assign alternative courts where a court cannot function due to COVID-19. To conduct court proceedings using remote communication technology to facilitate the control of diseases and for such matters connected therewith. Therefore, the law it proceeds to say in section 2 that where any court, tribunal or other authority established by or under the law is satisfied that a person was prevented from instituting or filing any action, application, appeal or other legal proceedings, as the case may be, within the period prescribed by law for such purpose, or performing an act which is required by law to be done or performed within such period, due to COVID circumstances, it is competent for the court, tribunal, or any other authority established by law to admit and entertain an action, application, appeal, or such act, notwithstanding the lapse of time period prescribed by law for such purpose, and subject to the provisions of section 9, which is incorrectly typed, should be section 5, the period within which such person was subject to such COVID-19 circumstances shall be excluded. Therefore, if an action had to be filed or an application has to be instituted or some act had to be performed, which could not be done within the time because of the restriction imposed due to COVID-19 pandemic, then that period will be excluded in calculating the period within which you are required to comply with that. So you will see that there is no blanket cover given for a person by this process. By this act only provides this, the period within which the person was in fact subject to COVID circumstances will be calculated to exclude the period within which you have to comply with that. Therefore, one cannot at his whims and fancy, you cannot wait for such period to file action. If the action is to be done on the 14th of a particular day, and that could not be done because of COVID circumstances, and that ended within a period of 1 week, then in terms of the law, you will be excluded given a period of 1 week and not more. So the law only provides the person to get relief for the period during which, or during the period during which he or she was unable to perform what he could perform. So that period will be excluded by law. And that is also upon the court being or the institution being satisfied. And the burden of satisfying that you were subject to COVID circumstances is upon the person who is seeking that application to be made. You must, in terms of the law, the court, you must get permission of court where you have not complied with that. And this covers a wide area, not only the court, not only tribunal, area institutions. So therefore, I mean, all the tribunals which perform certain function as regards the rights of the people, or any other authority such as income tax department, or any other where you have to comply, we have to make your returns on time, you have to make your payments on time, you have to make your deposits on time. If you have failed due to the COVID circumstances, that period during which you could not comply will be added, provided that it is established you were subject to such circumstances. Now the period in giving this, what is the section 5 also makes it clear that the period that can be excluded cannot exceed 18 months in total. It says, section 5 says, the period excluded for relief on section 2 shall not exceed 12 months. However, the period exceeding 12 months may be excluded as a relief where the court, tribunal, or other authority is satisfied that it is just and equitable to do so, and then you can give a further period not exceeding 6 months. And it also provides that the total period, aggregate of the period that relief can be granted cannot exceed more than 18 months. So maximum period 18 months within which you have to file and comply with the obligations, and that too, you cannot wait for a period of 18 months. You have to establish the period within which you were in fact prevented, and that period will only be calculated for purpose of giving relief. Then this subject to interpretation of court, I think it will be a very, very wide scope, and the application, the circumstances, COVID-related circumstances has been defined in section 8, which seems to be quite a wide definition. COVID-19 circumstances includes COVID-19. So a person who has suffered from COVID-19 is included, or any other circumstances arising out of or consequential to the circumstances referred to in paragraph 1. Therefore, it covers various other aspects where you have not suffered, but in view of COVID-19, if there was restrictions, where you travel restrictions or isolations imposed, where you are not affected, but if a member of your family was subject and the house was put to isolation, then you cannot proceed to perform your legal rights or obligation. You are excluded. Similarly, that would cover all steps taken which will affect or which will prevent a person from performing his rights and obligation, where all those circumstances will be covered. I suppose broadly, if I consider this, I could think of some of the instances will be where the litigant is tested positive, where the litigant's family members are tested positive, and or the litigant is the first contact or under quarantine. If the court is under lockdown or the area is under lockdown, if the instructing attorney is tested positive or under quarantine for any of the reasons set out above, inability to obtain mandatory documents from public or government institutions which are closed down or operation has been limited in view of COVID circumstances, subject to mandatory quarantine after being arrested for various things such as violation of protest, inability to serve notice due to lockdown, actions against state and officers. So similarly, I don't think that the circumstances can be limited. And this act has been enacted for a particular purpose to give relief to those who could not exercise their rights and perform their obligation due to circumstances beyond their control. Therefore, I am confident that in interpreting this act, our courts would do it to somewhat in a flexible way to give the maximum relief, and only the limitation would be to prevent an abuse of the process of this law. So the definition, in terms of the definition, I think the act is very broadly drafted, and all the circumstances could be included in this. Then the act, as the preamble says, the second purpose is to assign alternative courts where a court cannot function due to COVID-19. Now, we have seen in the recent past that many courts could not function either because of travel restrictions or officers performing their duties in the court or court complex have been identified as COVID patients or various other reasons. So questions therefore had arisen, is it just for the litigants to suffer for this reason? What happens to their cases? There are many cases which are of an urgent nature. People are waiting for their reliefs in custody matters, certain payments, where a house or something is to be destroyed by a unauthorized way. So the very legitimate rights, those must be exercised promptly. Otherwise, your rights can be greatly jeopardized. Therefore, this alternative court concept was considered And the court has now, the law has now enacted that where the performance court cannot function due to the COVID circumstances, the Judicial Service Commission is entitled to nominate the nearest court of concurrent jurisdiction in terms of Section 3 of the Act. It says subject where the ordinary functions of any court of first instance is disrupted due to COVID-19 circumstances, Judicial Service Commission may designate the nearest court of concurrent jurisdiction as the alternative court in place of such court for a period during which COVID-19 circumstances exist. Now, any action proceeding or matter filed or considered by such court of first instance or any new action considered shall be considered to be heard and determined by such court designated. Then the also says the transfer of to an alternative court will not take place in two circumstances: where the case had been concluded and it is reserved, or case is the order the pronouncement of the judgment order is reserved, or where the case is concluded before the court of first instance. Such cases will not be where judgment is reserved or order is reserved, or even before the order is reserved, the entire proceedings are concluded. Then such instances, the cases should not be transferred. Similarly, it also says once a court, the cases are transferred to the alternative court, that court will proceed as if that is the court of the first instance in which such action should be instituted. It also says in terms of the proviso to Section 3, Subsection 2, is provided that no transfer of action proceeding or matter in referred to instance shall be made where alternative court has already reserved, that is where the alternative court concludes the proceedings and order is reserved or judgment is reserved, or hearing is concluded, the alternative court should not retransfer the case to the original court. Otherwise, the moment the COVID-19 circumstances ceases, the alternative court is obliged to transfer the case. Now, the process in which the cases will be transferred in terms of the determination of the Supreme Court is that's a matter that will be provided for by the Judicial Service Commission. So that's a practical matter. No doubt we may have difficulties, but with all the difficulties, this process is good. Then the third circumstance for which the Act has provided is to conduct proceedings using remote communication technology. So where a person is unable to appear in court or proceedings of the court cannot be conducted under ordinary circumstances, this facility is given. And on this matter, I am confident Mr. Alagaratnam President's Counsel will enlighten you more fully. Then also the manner in which the Act is drafted, I believe you might have to get permission of court on the basis of COVID-19, establishing COVID-19 circumstances for you to for your action or act to be accepted by court. The manner in which it must be taken, application must be made, the circumstances, how the circumstances and the manner in which it must be established before court, I am confident Mr. Lankatilaka will deal in more detail. So overall, when you consider the Act, we are very happy as lawyers that the Act has provided for something that is the need of the day. And also in granting extension of time, the Act also states that where the Supreme Court, in respect of appeals and application to Supreme Court and Court of Appeal, the rules have been promulgated by way of gazettes which are referred to in Section 2, Subsection 2A. The court should not interfere with them because those are governed by the Supreme Court rules. There are 4 gazettes referred to, 3 gazettes in fact. Gazette number 2174 of 6 May 2020, 2211 of 56 of 21st January 20, and 2175 of 2 of 12th May 2020, and also it also refers to any other rule that may be promulgated by the Supreme Court or the Court of Appeal as regards the period during which they would give concessions. So the period within which the concessions are given by the Supreme Court, the Court of Appeal, no court or tribunal can interfere with them, and these rules will not apply. So overall, considering this act, I think we are happy that this has provided for the most needed relief that should be granted to the litigants, and also the manner in which the act has provided for remote communication evidence enables us to proceed with litigants' causes with all the disruption. So I believe I have given a general introduction of the newly born act, which is still to see how it will operate. And I am confident that we as lawyers and the lordships and other judges will have a broad view of the law and will have a flexible approach to give effect to this and to see that the full use of this act is enjoyed by citizens of the country. Thank you very much.
Thank you, sir. I think you have given an extensive introduction, not a general introduction. I think covering all the aspects of the act. So before moving to the next part, sir, there are two pertinent questions arising out of that. One we have received, and of course, arising out of that, the other one question is also connected. That is with regard to the Supreme Court determination. We have received a question asking why on what basis the Supreme Court decided that the chapter with regard to contracts are not in line with the Constitution. We know, I think you know
That's
that
right.
we all wanted that section, we all wanted that chapter to go in. But
no, that I suppose that chapter basically was something that was thought of by the Ministry of Justice, and also in our elaboration, Mr. Jeffalagaratnam was very active. Mr. Sanjeev Jayawan, the President's Council, with their collaboration, we had this different thoughts. But as a whole, they thought we must give relief in terms of the thinking of the ministry, and therefore certain contracts were enumerated in the schedule. Those contracts, the Supreme Court, the majority decision has pointed out, deals with only a particular kind of contract, and they have their lordships have taken the view that there is it affects equality, equal treatment as regards other people, other persons who have entered into similar contracts or any other contracts, and they are questioned why only this contract has been specially spelled out. The lordships have taken the view that violates the principle of equality, fundamental rights related to equality under Article 12(1) of the Constitution, and they have said, therefore, if you are going to give special right to this commercial contract, they term the commercial contract, that must be passed by a special majority.
So the other matters are now this. If I can draw your attention to the interpretation clause, there was another deliberation in the Supreme Court determination with regard to the COVID circumstances, whether the interpretation COVID circumstances would capture a situation where some situation arises in a foreign country. Take an example, if a lockdown is imposed by a foreign country and a person living in Sri Lanka is affected by the rules brought by a foreign country, whether it would be captured within the interpretation.
Now that question I think particularly dealt with by His Lordship Justice, the dissenting judgment. Right, His Lordship have pointed out that will that can be caught up within subsection B, which says any other circumstance arising out of or consequential to the circumstances referred to in paragraph 1. Paragraph 1 is COVID-19. So there is no reference made to COVID-19 within Sri Lanka. Oh, so COVID-19, that pandemic is today a universal pandemic. So a person who comes from another country, or in view of the COVID, the circumstance that there is in another country, travel restrictions were imposed, or for some reason he could not comply to come to Sri Lanka on time in order to comply with the legal obligations or to enforce his rights. I believe, as His Lordship in the dissenting judgment has pointed out, that would cover any other circumstance arising out of consequential to a circumstance. This relates to COVID. So whether it is within Sri Lanka or outside Sri Lanka, the difficulty or inability to perform had arisen due to circumstances that arisen out of COVID. Although it is not in our country, in another country, due to which he could not perform rights his obligations in Sri Lanka. So I believe such a wider interpretation could be given, although that provision has been removed on the basis that seeks to introduce a foreign law into our country, or that would jeopardize or it will interfere with the judicial independence. Perhaps a broader view could be given by our judges, I think. And I'm sure our lawyers will also cooperate in achieving that objective.
Thank you very much, sir. We'll come back to you again, sir. Now, moving on, as Mr. Ikram Mohammed, President's Counsel, went through that, and one area he pointed out is the procedure, the burden of proof and the procedure. How we are going to the COVID-19. He elaborated the COVID-19 circumstances. Now, can we maybe invite Mr. Lankatilaka, President's Counsel, to elaborate on the burden of proof? Now, supposing a person is caught up in COVID-19 circumstances, so this does not give a blanket cover. You have to go and prove that you were affected by COVID-19 circumstances. So therefore, the Act in Section 6 has laid down the burden of proof, and of course, and Section 7 gives some guidelines. So maybe can we invite Mr. Lankatilaka, President's Counsel, to enlighten us how a person affected by COVID-19 circumstances should go before court or go before any other tribunal and seek the relief given under this Act. Mr. Lankatilaka.
Thank you, Mr. Kanwarachi. I will straight away go to the area. You see, firstly, I must say, if you know that when you have to file an action in a district court, you have to file a plaint. But at the time of filing the plaint, you know that you are out of time. Then you have to plead the delay, and the delay is due to the COVID-19 circumstances. And having pleaded in the plaint, in the prayer also, if you seek permission from court to proceed with this section, then for our purpose, that is enough. Then the subject of proof, as far as when this is an example in the case where you are the plaintiff in an action in a district court. Then in the Act, Part 4, Section 6 says the person who makes the application has to prove that there was COVID-19 circumstances and which prevented him from filing the action within the period prescribed by law. Then Section 7 of that says any guidelines, directions, circular, notice or decision, whether in the printed or electronic form, made by the government in relation to COVID-19 circumstances shall be admissible prima facie evidence in any action. So all what we have to do is, if your application is genuine, you have to obtain the documents pertaining to the COVID-19 circumstances. So those documents are available in the official government news portal or else in all the other organizations. For an example, now in this country, this type of lockdowns or travel restrictions are being done by the government in collaboration with the MOH office. There are MOH officers, several MOH officers are in a district depending on the density of population. For an example, in Colombo there are about 50, in Kandy about 23. So under them, there are PHIs, the public health inspectors are working. And then military and the police work hand in hand. They just don't come without any writing. They must have records in their institutions. So whatever the documents available, so at the time of filing the plaint, if you have the documents in your hand, then you can file the documents also and plead in your plaint that there was such a situation which prevented me from filing the action in time. In the prayer also, you can seek permission to proceed with the action. If you don't have the documents at the time of filing, then of course you can retain the rights to file the action, file to submit upon receipt of this document. So it is a situation where you have to file a plaint, knowing that the course of action is prescribed. Similarly, if you in a situation where you have file an application for an injunctive relief, then of course you must go immediately to courts, but the documents are not available. But then of course, somehow you must go along with the documents, available documents, to courts, and at the time of supporting for an injunction, you must have the documents in your hand, because otherwise, thereafter, court will not allow you, grant you permission to after supporting the matter. I don't know, there will be difficulty, but anyway, there is a discretion which can be exercised by the judge. Then, as regards to the leave to appeal application, there is a time period within which you have to make that application, 14 days. So if you of course within that period, if you are unable to file the application, then that also can be pleaded. If you have the document, of course, along with the petition, you can submit papers. Otherwise, you can plead that the permission can be obtained from Supreme Court of Appeal to submit papers when the papers are received by the petitioner in due course or something like that. Then, in the petition of appeal, there is a time period within which you have to do the appeal. In the petition of appeal also, you have to plead. In your petition, there is a delay due to the COVID-19 disturbances, and in proof thereof, if you have the document, you can submit at that time, or else obtain permission to submit them the moment you receive those documents. And it is advisable for the practitioners to plead in your prayer also for the permission under the COVID-19 Act. Then, as far as the courts are concerned, we all know that not only the district court, we are dealing with the magistrate court, especially application under Primary Court Procedure Acts, within 6 days, if you file action, there is useless because your action is going to fail. Then, of course, there also you can plead, if it is a private plaint, of course, you have to plead that there was a situation like that. And whatever the available papers, you can file the papers and try to invoke the jurisdiction of the magistrate with regard to the application made under primary court procedure. So then as far as courts are concerned, now if it is the list of witnesses, of course you have to file in time. But if suppose you fail to file in time due to these problems, then the best thing is you can file a motion along with the list of witnesses, and in the motion you can state that there was a delay, and delay is due to COVID-19 disturbances, and in proof thereof, I hereby forward document ABCD. If you don't have the document there, also you can submit that the documents will be submitted to court the moment you receive the documents. Then the other institutions which are referred in that, of course, you say you have the other tribunals. Sorry, other tribunals like labor tribunals. If a person is suspended from services, then within 6 months you have to make an application to the labor tribunal. So COVID, if you couldn't do it due to COVID related situations, then of course with the papers, with the reliable papers, you have to make the application. Or else you can the rights to file those papers later on. Then you have instances where there is a agrarian, the agricultural tribunals. If a tenant cultivator is ousted, then he has to file action papers within a period of 6 months. Similar application has to be made with those documents. And according to the section is very clear. If you make your application with the document, section 7.1 says any guidelines, directions, circulars, notices, decisions, whether in the print or electronic media, the government, the COVID-19 circumstances shall be admissible evidence, prima facie evidence in that action. That's all what you have to do. You have to submit admissible, prima facie, genuine documents in courts. Once that is done, the court can exercise the discretion. Then subsection 2 says, if the other party disputes the authenticity or the admissibility, then burden shifts to the party who is objecting, who is challenging the admissibility of the document to establish that the document is a false document or there was no COVID disturbances during that period. It is on the cast on the other party. Therefore, act is very favorable as far as the litigants are concerned. So they have, as far as possible, if you can go with the genuine document, prima facie genuine documents, then of course you don't have to worry about proving that document because there is a discretion vested in courts. They say shall be admissible as prima facie evidence in any action. Therefore, subsection 2 says, if a person wants to dispute the admissibility of such guidelines, directions or circulars, notices or decisions as evidence, the burden of proof shall be on the party who disputes such admissibility. So this is the situation. As regards to the other institutions, like if you can't file returns in time in the Revenue Department, delay can be justified by producing papers and establishing, then justifying the delay. Delay is saying that delay is due to COVID-19 circumstances. Likewise, there are other instead of the customs, there are inquiries. they assign a time period within that you have to pay the penalty. Similar remedies available. Now, the municipal council, of course, they say within a certain date, or no below such and such a date, you have to pay the arrears of rates which are amounts large sums, and otherwise they say they are going to auction the properties. Then this act will be helpful to those people if the delay is genuinely due to the COVID-19 circumstances. So now, obtaining papers, of course, after filing the plaint in courts, of course, you can make an application to courts under section 441. You can make an application to courts and then obtain an order for the necessary institution to give those documents to you. Otherwise, you can personally write to them, because very easy. You can approach the police station or else the MOH office, or the letter from the Grama Sevaka certified by the divisional secretary will be sufficient evidence, because invariably the Grama Sevaka is involved. The local authority officer is involved. Health ministry officials are involved. Police is involved. So they have notes in their police stations with those documents. And then if you can obtain a letter from the PHI, Public Health Inspector, certified by the MOH in the area, stating that this area is locked down, then that document is prima facie, I say, prima facie, a genuine document on which you can rely on. And as we discussed, there is another document. If you are down with COVID-19, then there will be yellow color notice pasted, pasted on the door is sufficient evidence. With that document, if your name but the assessment number will be there, if your name is not there, you can obtain a letter from the Grama Sevaka or letter from the MOH office. Then that will be sufficient evidence. The other evidence, of course, government notices, paper publications, all these things are available to public and obtained without any difficulty. Therefore, I see the subject to proof, the proof of the fact that there's COVID-19 disturbances in that area. I was prevented from going to court because of this, can be proved without much of a hassle according to the present act. Therefore, all what I have to say is the act is very good and we can make use of it. Basically, those are the areas, these are the things that I can say at the moment. Thank you very much.
Mr. Lankatilaka, thank you very much. But before moving on, now may I again draw your attention to section 7.3 of the Act, where it gives a broader interpretation to the government. Now, yes. Does that interpretation cover all these people you just mentioned? This Grama Sevaka, MOH, PHI, police, everyone can be brought in under the interpretation of section 7.3.
I think yes, because if you see the original act number, I think act number that's quarantine pandemic some act, they say in such a situation when there is such a pandemic, health ministry has to do all this with the police, and invariably with the military, because they have an organized system. Without their help, you can't proceed. In fact, the Grama Sevaka is a government office. So you know you have the details of each and every household. And the MOH office comes under the health ministry. They are invariably government officers. And military is also government. So definitely that covers a larger area. So if you take a letter from the Grama Sevaka, countersigned by the divisional secretary confirming, I think that's good evidence as far as this act is concerned. All the act says without the services of military, you will not be able to curb this type of pandemics.
And also, if we see section 7.3, it says an authority defining any regulation also, not only in that, any authority defining the regulations. If the regulation has been put out by the health ministry, assigning certain duties to officers, won't they come under this particular interpretation?
Yes.
And also, yes, also section 7.1. When you say section 7.1,
yes, yes.
Has it given a wider option for the people who are seeking relief? Guidelines, directions, circular, notices, decisions. So, has it given a wider discretion?
Certainly yes. Certainly yes. It says any guidelines, directions, circular, notices, or decisions, whether in the printed or electronic form. So we have instances where the police officers, some evenings, police officers go on announcing in a try show, announcing that this area is going to be blocked from 6 o'clock today until Friday morning 6 o'clock. So probably that type of announcements, the announcement may not be recorded somewhere, but in the police station, police officers don't go without writing something in their notes. Even if that is not available, you can obtain some affidavits from respectable people, and because there is a wider, because all of a sudden, without the knowledge of anybody, police goes on, cordoning areas and sealing areas and prevent people from going out and people from coming in. Then within such time, of course, people are prevented from doing any act. Even if there is a court case, or you have to file an action, or you have to go to the Inland Department, you are prevented from doing that. So that is also included. I think this has a very broad meaning in this. Under section 7, all those areas are covered. As far as I see.
One question, we have received a question from one of our participants. He is asking if one is under self-quarantine, whether this act would apply, and how do we prove that?
Yes, all what you have to prove is the reasons for self-quarantine. If you are working in an office, if you can establish that I am working in that office and 2 individuals contacted COVID-19 disease during that period, that would be enough for me to say that law requires you to quarantine yourself in your house.
If a member of the family has got positive, PCR report might be useful.
Yeah, there are PCR reports. Yes, that is also another thing. So even the notices, yellow color notice is sufficient, because I am not allowed to go out and behave in the society if one of my family members got contacted COVID-19. Therefore, this has a very wide meaning, and I think this is nicely, as Mr. President, Ram Mohammed, President's Council spoke. This is a nice piece of legislation. We can make use of it.
Thank you very much. Thank you very much. Before moving to the next part to Mr. Alagaratnam, President's Council, may I again come back to Mr. Ikram Mohammed, because when it matter arising out of Mr. Lankatilaka's presentation.
Yes.
Now, sir, do we have Mr. Ikram Mohammed, President's Council here?
Yes.
Sir, now if we just compare the section section 2, sir, section 2, latter part of section 2, isn't there a similarity? Word to word, if you take word to word, isn't there any similarity between these wordings and section 765 of the Civil Procedure Code, where it deals with appeals notwithstanding lapse of time? So by looking at that, can we take some inference about how one should proceed to prove COVID-19 circumstances, and how should be what procedure should be adopted?
It's, and in terms of that, you are referring to the appeal notwithstanding lapse of time.
Yes.
Now, in that, in
Maybe,
terms, correct, no?
Yes. Yes.
The section
765, sir?
65.
Yes.
Now, in that section, one has, it's a provided the court will be satisfied that the petition was prevented by causes not within his control from complying with the provisions.
Yes.
So that is your question is very good. It's really you can draw a great inference from that. As Ms. Lankatila pointed out, the circumstances which prevented you from coming to court on time must be set out necessarily in whatever the application that you make in seeking redress. So that will be a precondition with which provided the court of appeal. Similarly here, provided the court or the body or tribunal is satisfied that the petition was prevented by COVID-19 circumstances. So that must be set out, and the relief in terms of that must be sought. And that could be granted by court exercising, or the body exercising its authority only where it is satisfied that the person was in fact prevented by such circumstances. So in court, it is a judicial mind has to be applied there, but in other body, they have to exercise that mind to consider whether this particular circumstances have in fact affected this person from presenting or complying with that on time in terms of exactly what is set out in Section 765 in the Civil Procedure Code. So that's a good example. Very good thinking.
Sorry, sir. Do you think that this should be taken up as a preliminary matter before proceeding into the crux of the matter? These are the substantive matters?
Yeah. Now, even in those application by the Court of Appeal, very often I have seen, although these applications not filed now, often those days they were filed, many of them, and their objections are taken by the respondent by the preliminary objection. That the material that is set out will not establish that he was prevented on the face of it. Now here, as Ms. Lankatilaka points out, if you produce the regulations, all those things which are applicable to your location, or to you, or to your lawyer concern, or to the courthouse concern, I believe that can be, that once it is set out, if there is no objection, then there is no problem. But if any objection is taken, then the court or the body or the person has to then go into that matter by where I believe by way of as a preliminary question to see whether on the face of it, primarily whether court can grant permission or not. In my view, if the objection is taken, will have to be decided first, and against any such decision in a court, we have a right of appeal by leave to appeal or by revision, and any other forum also, if it is subject to the jurisdiction of court, perhaps they can seek the relief from court. But in my view, that if objection is taken, court might have to decide that matter as a preliminary matter. Similar objections, on the basis of cause of action or non-disclosure of cause of action, or the material do not establish, some of the preliminary provisions are there. So similar things might have to be taken. And in that context, I think as once we had also discussed section 46, 46 subsection 2 provides so will also be material. Now it says where the relief sought is where the action appears from the statement in the plain to be barred by a positive rule of law. Now this is similar circumstance. If it is out of time on the face of it, then it is barred by a positive rule of law, unless exemptions are given. Now Civil Procedure Code provides for exemptions to be shown in terms of section 44. If the cause of action arose beyond the period ordinarily allowed by any law for institutional action, the plaintiff must show the ground So I believe here too, one must show the ground upon which you are claiming exemptions. Otherwise, the payment is liable to be dismissed or rejected. And once it is shown, and if the other party objects, then I believe probably that will be taken as a preliminary objection rather than deciding that matter at the end of the trial, which will be a waste of time and money, time of court, time of people, and which will also put people into a lot of unnecessary expenses.
Thank you, sir. Thank you very much, sir. Now, moving to Mr. Alagaratnam, President's Counsel. Before we move into the remote evidence part, there is a question I think I should put to you. There is a question saying it was evident that many of checks deposited to banks during lockdown period have been returned with the mark of credit not verified under these circumstances. So that I also have experienced that some of my clients also have come on this basis. The bank has some banks have dishonored the checks on the basis credit not verified. The question now this particular participant is asking us: can a creditor take legal action based on such check returned under the remark of credit not verified? What the bank says, the meaning of credit not verified, they could not contact the paying bank, and therefore they could not honor the check. So if not, what are the remedies available to such creditors when the bank now refuse to accept such checks due to the lapse of 6 months' time? So, can you answer this, Mr. Alagaratnam, President's Counsel, sir? Before you start.
This is an entirely new concept that has come in of late. Something hitherto unknown to the law. So, and then it is not something for which the drawer should be held responsible. If there's a breakdown in the communication between the paying bank and the receiving bank, so that, of course, I suppose it might have been created due to the COVID situations. So what you're saying is that they have been told credit's not verified.
Yes.
So I personally feel that the creditor should call upon the bank to verify it and get back, or should either coordinate. I mean, if you want to have a practical way out of it, the drawer to liaise with his bank and ensure that it is paid out, because if the credit is available, or the bank, and there should be coordination. It seems to be a coordination breakdown between the two banks. So for which neither the creditor nor the drawer should be held responsible. And this cannot be considered dishonoring of a check, no? Because normally payment stopped by drawer, or effects not realized, or account closed is a dishonor of the check, because that is entirely maybe something within the control of the drawer. So as far as I can see, your question is whether the creditor has a recourse against this bank that writes and says credit is not verified. Is that your question?
Credit is not verified. I have also come across this remark where the bank has returned the checks on this basis. Now, by the time bank opens, the time of the checks are left. Now, the debtor, the drawer also refuses to pay the check on the basis pay any money, saying that it is your problem with the bank. So this particular participant is asking, under these circumstances, who's liable now? I have not received my money. The bank has not dishonored. The drawer is not paying. So against whom I should take action? Anyway, I have paid you. It is your responsibility to get the money. In terms of yes.
But the point is, if you have not got the money from the drawer, then the drawer remains liable for it. No, because if the check has got frustrated in between by supervening circumstances, then there is a no valid payment in fact and in law. So you just handing over the check to your bank for whatever it is to be, if it's not realized for whatever reason, then the drawer remains liable for the payment to the money. Whether you can sue the paying bank and the drawing bank is two different things for their breakdown and their inability, but they will plead circumstances where there is a failure of electronic communication. So I think that presents a rather curious problem. You will have your action against it.
I think what Mr. Lasita is seeking to clarify is now the reproducing the check to the bank could not have been done because of the COVID situation.
Yes.
Now, once the bank, for whatever reason, returns the check, and by the time the check is to be presented again, you are entitled to present. The period of 6 months lapses because of the COVID circumstances. If it is due to COVID circumstances, could the customer seek relief under the provision?
And also the bank, whether the bank can accept it after 6 months.
Yeah, whether the bank is obliged to accept granting the relief.
Yes.
I would think that under such a situation, you might be able to invoke Section 2, because it says that any authority, any body, because if I remember
That's right. That's right.
the section is broad enough where it says court or tribunal, any other authority established under any law, which says authority under any law for filing of an action, company of such court, tribunal, or other authority, whether the banking authority or the central bank or anybody can be sued. I don't know whether you
now here you have to present it within 6 months.
Yes.
The inability to present within 6 months were due to COVID circumstances. I believe the law should be broad, liberal enough to include that situation, and where the bank could be called upon to give a concession of extension of time beyond a 6 limit due to circumstances. But that sounds rational, and we have to wait and see how the law will be interpreted. But it seems to be so, Mr. Alagaratna.
Yes, correct. And also the draw, it should work in reverse also against the drawer, where the money is owed to somebody and he hasn't got the money because of COVID and certain circumstances beyond his control, and therefore the drawer remains liable. Apart from the bank also.
But there is a provision, I think, in the Bill of Exchange Act, when payment is accepted by a check, you can't sue against the drawer. So that may be the difficulty the participant is having.
Yeah. Yes.
Yeah, but then the point is, when you accepted by a check on the day, why can't you sue the drawer? Because if you accept a check and the check has been stopped payment, you sue the drawer. Or if you accept a check and the account has been closed, you sue the drawer. So mere acceptance of the check doesn't completely absolve the drawer.
But the problem here is there is no dishonor. That is what he is asking. There is no dishonor or account closure. It is the bank's fault. Bank has not paid.
Yeah, so it's neither the creditor's fault nor the drawer's fault. But then the fact, yes. But then there is the aspect of unjust enrichment.
Just the aspect won't the word dishonor include the circumstances of non-payment for whatever cause? You present the check. Bank returns the check, and to that extent, the check remains unpaid and dishonored by the bank.
Yes.
So,
but of course, Lasita's question is that the drawer is saying, what can I do? I am not responsible for the dishonor. And the bank is saying, what can I do? I am not responsible for dishonor because I have not been able to verify the credit. And so the liability of
the drawer, as Jeff points out, the drawer will continue. We will be held liable because money has not been in fact gone.
Yeah, gone. So,
and it's not due. Interesting point.
Yes, I'm on my file action now.
No, that question is in fact before me also. Thank you very much. Thank you very much, sir. Now there is another one. There is one more question to Mr. Alagaratnam. Now one participant is asking whether this would apply to the Inland Revenue Department.
What would apply?
The reliefs given under the COVID-19 Temporary Provisions Act.
Should. No, that was, I think Mr. Mohammed dealt with that already. I think Mr. Lanka-Tilak also dealt with it, because it's any authority where there are time bars and time limits that a person who is prejudiced by delays should be able to plead the COVID circumstance to say, look, I could not comply and you cannot punish me or you cannot treat me as a defaulter because there are circumstances beyond my control. And therefore, I'm entitled to these extensions of time, which are reasonable in the circumstances.
Thank you,
it doesn't only cover a court. Yeah.
Yes. Thank you, sir. Now, moving back to the main point, you have to address. Now, this is with regard to the part 3 of that, conducting court proceedings using remote communication technology. So, what is the legal background and what is the legal cover given by this act for that, and what are the other supporting. Now, the act also refers to the certain regulations, the gazette regulations. What does they contain and how are they applicable?
Well, yeah, thank you. Before all that, I would like to first say that it's a good start to have had this act. It's a good thing that has come. It's a long time coming. Thanks to an energetic Minister of Justice, this has got done, though I think Mr. Mohammed and I and Mr. Lanka Teleka were involved in January to try to get this through, and it has taken 8 months, notwithstanding the minister's keenness and the enthusiasm. There seems to have been some roadblocks on the way, which is unacceptable, because if you see countries like Singapore and India, they have started last year. So it's a long time coming. Better late than never. It's a good piece of legislation. Maybe more could have been done, because I can't see why we took so long, especially because we rushed so many laws, like, for example, the 20th Amendment, the tax amnesty, the Port City Bill. But this has given least priority, which most affects the citizens of the country. Because I think the legal system is as important as the health system. And we have to look at it almost on the same level in giving relief to the people, because we serve the people. We don't serve the judges or the lawyers, but the people. So that is something that should have been foremost. The Minister of Justice has done everything within his power. We congratulate him for it. But I wish that it would have been done much earlier. This piece of legislation, unfortunately, is only temporary, which it allows courts and says only in certain situations. If you look at Section 4 of the Act, if I may have it on the screen, it refers to a situation where any person is unable to appear, or B, that is under Section 4(1)(b), or the proceedings of the court cannot be conducted under the ordinary procedure. So it restricts it to two situations and says you can use television, video, or some electronic means to conduct the proceedings. So it says notwithstanding in any other written law. I think that though it's the COVID Temporary Act, this is a very salutary principle, and this is a thing for the future. We don't know when COVID is going to finish. Unfortunately, this act says there's only 2 years and another further 2 years. But I would think it's something that is very salutary and to be adopted even by the courts of first instance, and that is where on a permanent basis. And I don't see why I've always thought that if you look at Section 167 of the Civil Procedure Code, I think Mr. Mohammed also taught me in the university, of presence. You know that when we have contracts today, we have moved away from those days where we have a lot of electronic means. When a person speaks on a telephone or on other electronic media like Skype, they are virtually speaking in the presence of each other. The Civil Procedure Code talks of evidence being given in the presence of the judge. So isn't a person giving evidence on a television screen to the judge in the presence of the judge, just because he's physically miles away? So I think this cuts down loss delays, this cuts down costs, except that you have to make sure that the procedure is foolproof, where there is no coaching, tampering, or false evidence given, or perjuring. So, and this, fortunately, it has come in for this purpose. As Mr. Lasitha Kanuvararachi says, we follow the various rules of the Supreme Court and the Court of Appeal, electronic rules, and any other Supreme Court rules that may be promulgated in this connection. As mutandis will apply. It's fortunate it refers to Section 136. Now, the Supreme Court has wide powers to make rules. If we read the Section 4, it says, okay, notwithstanding anything contained in any other written law, where in any action, application, appeal, or other proceeding before a court of first instance, magistrates court, court of district court. Unfortunately, in this section, whether the labor tribunal is a court is not very clear, but there have been judicial decisions which say that a labor tribunal is also a court. And I can also say with responsibility that we have conducted video proceedings in the labor tribunal Battarampura, cross-examining witnesses in America and cross-examining witnesses in Saudi Arabia. Look at the time saved. Look at the travel restrictions now, even in the future. Look at the cost, the time for travel. If a person has to come here, he has to take leave from his office. Whereas if when you do remote controlling and video, it is just a matter of taking him off for 3 hours or 2 hours from his office work, and he gets back to his home or his office to continue his normal lifestyle without jet lags. So this is first instance where a person is unable to appear. or the proceedings cannot be conducted under the ordinary procedure. Today we know we have this Delta variant, it's widespread, people are dying. So, I mean, I think any court proceedings where even there are about 10 or 20 people is a dangerous situation. Of course, fortunately, this section also provides, of course, the use of video or live television and the use of the Supreme Court electronic filing and urgent digital virtual hearings. And if we go down, subsection 2 and subsection 2A and subsection 2B, if you go further down, you see, if you read through those rules, those are very elaborate rules that have been done by the Supreme Court and the Court of Appeal. They tell you how to file the action, how to scan and send your documents, how to send the originals. If it's urgent, you ask the registrar and the judge will decide whether it's urgent and allow you to support it. And so these rules can be streamlined further because they provide and they tell you must come 15 minutes earlier, you must log in, you must keep your video on because they must know who's appearing. All sorts of details are dealt with in these rules as to how the Supreme Court and the Court of Appeal will be handling cases. Not only merely mention cases and support, it should also be virtual hearings. Of course, in the case of Supreme Court and Court of Appeal, it may be a little easier because there is no oral evidence given by a witness. Cross-examination, re-examination may be much easier. Whereas in the district court or the district court in a remote area, you need connectivity. So you'll have to arrange the logistics to make sure maybe a witness is connected from an independent point where he gives evidence, where both parties are present to make sure that there is no false evidence or fabricated documents and to lead documents. So, of course, it is something that has certain practical issues, but it's a very good thing. And all these rules, the Supreme Court and Court of Appeal, if you read through those gazettes, you will see how they do it step by step about filing, giving notice, supporting, asking for urgent hearings, how you come to court, how you don't come to court, you get your laptop or your iPad, and how you log in and how you make your appearance. And of course, remember, you have to wear your coat attire. You can't come in t-shirts as one lawyer sought to do in India, and the Supreme Court said, we can't hear you. You're not properly attired. So there is the formality of court proceedings, but it's remote. So these are things that are very good. And if you notice, subsection 3 is very interesting. The Supreme Court or Court of Appeal rules as maybe made under 136 of the Constitution. We're in the period of operation of this Act. Unfortunately, as I said, it's always the operation of this Act. But if you look at Article 136, and if you look at Article 136L, it refers to all matters of practice and procedure, including the nature and extent of costs that may be awarded, the manner in which such costs may be taxed, and the stamping of documents in the Supreme Court, Court of Appeal, High Court, and courts of first instance, not especially provided for. So the Supreme Court has wide powers, is my personal view, on passing further rules and even modifying their own rules for electronic hearings, for video, Skype hearings, so that this is a thing of the future. Because you have poor litigants coming from all over the remote provinces to give evidence, hanging around for hours and waiting, and in the end, case gets postponed. All this could be avoided, the time and consumption, if we work more electronically and for the thing of the future. There are practical difficulties, but those are things that have to be addressed by the Ministry of Justice, the court system, as to where you record the evidence in a remote court. If, for example, somewhere far away in Sri Lanka, from where do the witnesses give evidence? Do they have sufficient electronic facilities and where they can give independent evidence? So these are fairly good developments of the law. As I said, unfortunately, it's confined to these temporary provisions. And I think I understand the Ministry of Justice is looking at going into electronic evidence, even and Skype and video evidence, even in the other courts like the district court. The Commercial High Court has done it, and it does still do it for foreign witnesses. And it has been one of the most practical ways of doing things. So I think this is a very good provision, which cuts not only for the pandemic, for various situations, and should be something adopted not only in this case, because anyway, this pandemic is not going to leave us for at least a year or two. So we are caught with it whether we like it or not. But even after the pandemic, it's something that would be best adopted on a permanent basis at all levels of court to prevent court crowding, to prevent waste of time, to prevent costs, and look at it from the point of the judges, the litigants. I mean, they know when to come in, when to give their evidence, and they go off. They don't have to be hanging around, spending money and time, traveling distances. And so, of course, under the previous laws, you know that the COVID Act has come in to clarify things. But there are plenty of judgments of the Supreme Court, particularly by Justice Mark Fernando and Gamati gave us a Siri about the Nelly and these cases, which show that time limits sometimes when there are situations where a person cannot perform due to circumstances beyond the control. The lex non cogit impossibilia. When you may, what I'm giving you large Latin words, not to impress you with my knowledge of Latin, but it just shows that something cannot be reasonably performed due to circumstances before your control. The court should excuse it because the law was made for the man, not man for the law. This is what the Coronavirus Act, though temporarily, seeks to do. And so, and also, fortunately, Skype and video is now getting more recognition because of the necessity. As they say, necessity is the mother of invention. But today we have, it's not the necessity anymore. I think it's a reality. It's something that has to be done for the future. And it's a fairly good job done by the legal draftsman in bringing this about. But I wish it is broader, right? Not on a temporary basis. And we can refine it as we go. Even this law itself is a good start. There are a lot of things that can be added and included. Maybe we have to look at it further to further develop it. As Mr. Mohammed and Lasita discussed, a lot of things were discussed at the start and a lot of things have got dropped by the way because of certain practical difficulties. But I think that's a good way to go. Of course, the legal draftsman finally has to take the brunt of it and do this, as they say very often. They say the legal draftsman, they say he's responsible for composing all the laws, and of half the litigation, he is undoubtedly the cause, and he gets blamed for everything. So whatever said and done, my take on this is that this is a long time coming. It's good it came, the law itself. As far as video and TV links, this was also a long time coming. It is something that should be a permanent feature from all points of view, especially not merely because of pandemics, for the overall efficiency of the legal system. Thank you.
Thank you, sir. One thing I can assure, sir, these temporary provisions will become permanent law very soon. Within 2-3 months' time, there will be a permanent provision. So now there is an interesting question, if I can put to Mr. Alagaratnam, President's Counsel. Now, one participant is asking, when we read section 2B, it covers all activities of any authority. So why not include commercial contracts? So this participant is asking whether the commercial contracts, the whatever the exemption for commercial contracts can be taken under section 2B, whether commercial contracts are covered under section 2B. Your thoughts on that?
No, of course, it depends on what the issue is. If you say that if you take a construction contract and you have not been able to perform because of the COVID, or let's say the employer has not been able to pay because of the COVID, then there is technically a breach situation. But then can you be excused because of the COVID? So I would think commercial contracts will also come in. Why can't you go into court and get an injunction saying, don't cash my performance bond? I can't perform because of the COVID. And also another person saying, or get a declaration that I am not in default because of this paying. So don't stop the contract. So it works both ways. But I'm not able to understand because that will have to be before a court or a tribunal or whatever it is, or authority established under the law. But you talk of construction contracts, you're talking of
I think what he is asking here, sir, now supposing there is a contract, one party is unable to perform his obligations due to COVID circumstances. So whether such party, when an action is instituted, or such party can go before a court or tribunal and say, look here, I was unable to, as in case of performance bond, I was unable to perform my contract due to COVID-19 circumstance, and therefore my performance should not be encashed. whether such,
Yes.
such position can be taken up in terms of section 2B of the Act. That is the question.
My personal view is yes, because you can go to court and seek a declaration that you're not a defaulting party because of the COVID circumstances. Of course, you know that normally in contracts, you will get a standard clause which talks of frustration, where circumstances are beyond the control and they cannot perform. Then they try to resolve it amicably, negotiate it, extend the time or whatever it is. But if those are not there to show a mechanism to refer it to a mediator or an arbitrator to extend the time or whatever it is, then you can go into court. Even if there's arbitration, you can refer it to arbitration and go into court and say that you have gone to the arbitrator to say that you are not in default and that not to cash your performance bond, you need an extension of time. But you can go into the commercial high court because the arbitral tribunal will not have the power to give you an injunction or a restraining order forthwith. Then you go to the commercial high court and say, I'm going for arbitration. If the status quo is not retained, I will be prejudiced. They'll cash my performance bond. I will be discredited with all the banks. So there is plenty of opportunities to go into court, even if those contracts have been excluded from the schedule for following the Supreme Court determination. Yet, my personal view is there is relief under the common law in a court or a tribunal to protect either party's interests. Unless, of course, the contract. Yeah. Unless the contract.
What Lasita wants to know is whether per se a commercial contract will fall within subsection 2 of section 2.
Yes, it is broad.
Yeah. Now, section 2, subsection 2 says from performing any act which is required by law to be done or performed within the prescribed period. So, to a statutory obligation as opposed to any contractual obligation. Therefore, I think that in terms of this, no contract, commercial or otherwise, would come under this. But you could, as Mr. Alagarathnam pointed out, you could use the other doctrines operation which would operate to get relief. Now, what I mean, it will not per se fall under this law. It is not any act or required to be performed by law. These are private contracts, public, So private contract will not fall. That is why we include the other section which has now been struck down, or it had gone out of the law. But as you pointed out, Mr. Alagarathnam pointed out, the doctrine of frustration, doctrine of implied terms, then the concept that it had become impossible to perform, those doctrines will come into operation, and based on that, you will be able to seek relief. But I don't think that will fall within this act.
Unless you give a liberal interpretation to the word required by law, because if you talk of contract, then you're legally bound to do something. By law, you're legally bound.
By contractual.
By contractual,
I believe this refers to statutory obligations. As against no contractual obligation. It's a statute.
But if you take the contract, then I see your point of view. But what I'm saying is, if you can go under the general law to a court.
General law.
But even under this section, whether there could be a broader interpretation of what is the law that I should be doing it under the contract. The law is that I'm a defaulter. So, and then I'm saying I'm not.
But it is not required by law to do that. The parties enter into an agreement, because it is not a stipulation done by law. Otherwise, you give the widest interpretation, which is all these things will come into. I don't think that was the intention of the legislator.
Maybe not.
Perhaps, this refers to, I believe, the statutory obligations, steps to be taken in terms of the law by every citizen, every litigant, independent of your private contract, in terms of which certain things have to be performed. But there, I think, as we discussed even at the committee our meeting, where the commercial law, commercial contract, commercial law, and the normal law provides sufficient defenses to cover those things, which I think may have to be expanded a little, given a little liberal interpretation by courts. Is that so? That seems to be
but
so.
Under the common law and general law, the courts, because you're saying that you're not defaulted, and because of this, there are frustrated, and then you're saying, don't treat me as a defaulter, restrain and retain the status quo.
In this I could not perform. I could not perform.
That's always available.
That's
Yeah,
right.
but
That should be-
last
that is
question
why
is whether we can.
that we have that relief.
Yes.
And
Yes. My
entitled
question was on this Act Section 2B.
act, I don't think
Yeah.
the act will apply.
Yeah. Then, sir,
It's fine
can you
with,
just
I
go
don't-
further? And there is another question. Can you just go further and explain little more how a force majeure situation can be applicable in this situation?
Yeah, force
can
majeure
you-
is of course under the common, because the fundamental principle of force majeure is where it is an unanticipated situation where nothing is, both parties did not foresee it, not because of the negligence of either party. Something happens which prevents performance of the contract. It becomes impossible. Impossible doesn't necessarily mean physical impossibility. It may be legally impossible. So that what happens is, if I have, for example, physical impossibility is where the war breaks out or something, and the ship cannot bring the goods to do the construction work because it's stuck in the Suez Canal. But legal impossibility may be, I agree to build your house for 10 million rupees. Tomorrow the government imposes a tax on cement and all that, and the contract value becomes about 30 million rupees. Now, can I perform? So there is a legal impossibility. So in which case, can you compel me and say, no, you do it for 10 million? So the way in which we wanted to perform the contract originally and the basis has failed. It cannot continue. That is force majeure. So there, of course, you're placing the burden on the party who wants to say that I can't do it, to prove the force majeure, that there was no negligence, unanticipated, there was a difficulty, not only physical difficulty, but legal difficulty to perform. So those here, of course, the law makes it a little more lenient, but it puts it in black and white as to what you should do to say I couldn't do it. You provide the documents and come under the COVID. But force majeure means there's a major force that has upset your contract.
Your control.
Control and destroyed it, so that to continue performance will be not to continue performance of the same contract. The contract is dead because of something. If you're forced to, you're going to do something entirely different.
Thank you, sir. One question on remote evidence. There is a question asked by a participant, say that now this section 4 of the Act is restricted to court proceeding. Whether what would be the legal situation of a AGM, annual general meeting held online? So can this law be used for that type of thing?
It can be, unless there is serious objections where majority of the parties, because what happens is, unless there is serious objections, because then it gets postponed indefinitely and then you have a problem there. But usually it is nothing irregular. We don't presume something to be illegal or wrong. And we are in the necessity or the circumstances of compelled inability to perform physically, we looked at the more expedient, practical, alternative way of carrying it out. So where there is a consensus in the company, in a company, the majority decides, and courts won't interfere unless there is fraud or crime. So if the majority shareholders are okay with it, just because the minority are against it, it'll go. But I don't see the rationale. As I say, it's presence. People are there present. You can verify that they are present. They are speaking. And unlike a court proceedings where a person can lie, maybe, and you have to monitor and make sure no fabricated documents are given or false evidence is given. In an annual general meeting, you will be reading reports. Somebody will be questioning the accounts. Somebody will be questioning the appointment, and others will be voting on a resolution. So that is much simpler than a court proceedings. So this covers only court proceedings. This doesn't cover a court of first instance. It doesn't even cover an appeal court. But if it's for a meeting or a club or anything, any meeting, even a director. Yes, that's the basic. It's nothing wrong in that.
Right. So
don't presume the illegal. The main principle is don't presume the illegal.
Yeah. When section 4 says, the other question, when section 4 says proceeding before a court of first instance, we have a question asking whether the first court of first instance covers LTs.
Cover
LTs, labor tribunals.
There is an argument in that favor because there are those several judgments. I think Justice Priyantha Jayawardena in the Supreme Court and Justice Kulatilaka in the Court of Appeal on that Upali newspapers cases. And under the new constitution, the LT has today been categorized as their court, judicial officers, the LT presidents, and they're treated as unofficial magistrates. So they are being given a status of a court, and they are the first instance where they hear the evidence and it's subject to an appeal. So I would think this is broad enough to accommodate an LT proceedings. And anyway, LTs have been doing it by consent of the parties. So my personal view is as a court of first instance, an LT could be treated as such.
One last question to Ms. Lankatilaka. There is a question from our notarial practitioners. They are asking what relief the notarial practitioners can get from this act. Ms. Lankatilaka, if you can just answer that.
Yes. As far as I see, that's also like in the interior department. If you can't file papers, your monthly list, and also the other documents in time, you can justify the delay. Like
how that should be done? How that should be done? Do you have to write, make a request in writing with the documents annexed?
Yes, whenever the opportunity arises, you can file along with your deeds and with the letter saying that there had been a situation where I could come out of my residence, and as a result, I am submitting there now, and in proof thereof, I am submitting some evidence saying that the area is close to something to that effect. And I think that also, that's also like similarly like you are dealing with the interior department or the customs or the local authority. I think same principle, same principle can be applied to the I think land registry or this registration of documents as well, because you can't go out with the documents and you have to physically hand over the papers. The post offices are closed. And also there is a possibility because they are working online, you can keep them informed that when the time permits, we can submit these papers.
Thank you very much. Thank you very much. And I think we have taken more than...
Lasita, 1 minute. Lasita,
yes,
Jeff, on the court of first instance, now the constitution seems to make a difference between the courts of first instance in 127(1) of the Act, Constitution. The Supreme Court is subject to the Constitution, the final court of civil, criminal, appellate jurisdiction, and and any other court of first instance, tribunal, other institutions. Yes. So that makes a difference between court of first instance and tribunal and other institutions. And also section 138. Yes. Article 138. Also in the exercise of court of appeal jurisdiction, it refers to appeal, revision, or restitution of all causes, suits, actions, prosecution matters, and things of which the High Court or Court of First Instance, Tribunal, other institutions. So that seems to make a difference. I don't know how the courts have interpreted this.
Because I would, that's a valid point that you're making, but my look at it is there are tribunals which are apart from the labor tribunals as such. We get agrarian tribunals, various types of tribunals. Now, the question is, in the context of the labor tribunals, there has been a history of whether they are judges or not judges and whether they are technically functioning as a court of law. But there have been judicial pronouncements of late, and if you look at the
judicial institutions,
judicial. If you look at judicial, they've been interpreted as judicial officers. So it's not. If you look at the definition of judicial officers in the Constitution, see, if you look at Article 170, any judge of the High Court, any judge of presiding over or member of any other court of first instance, tribunal or institution. See, so
that also makes a difference. The same distinction is made in the Judicature Act, section 38.
Or for the adjudication of any labor or other dispute.
Yeah. So they are judicial institutions, but that will not be regarded as court of first instance. I do not know. They are judicial institutions subject to review.
Yes. But what is first instance?
First instance are the entire system of normal judiciary that is established by the Judicature. If you say section 38, every court of first instance shall, in the case of appeal from such court to the Court of Appeal, and the Supreme Court confirmed the procedure. Now, the Judicature Act provides for the courts of first instance. Labor tribunal will not be apparently
under the Court of First Instance.
Yes, but that is the institution exercising judicial power. Therefore, appointment must be made by the JSC. But whether it will fall within the Court of First Instance, I have my doubts. I mean, just examine that situation, and on the face of it, since the law always makes a difference between first instance, tribunal, and other authorities, maybe it's excluded, but maybe I think Jeff is a better person to examine the thing always.
Yeah, you have a point there. You're talking in terms of the Court of First Instance.
Yes, and the
Judicature Act.
Judicature Act only provides the Court of First Instance.
But hopefully our labor tribunals will not take these technicalities seriously. So they can adopt it of consent. I don't think there are going to be any problem.
No, they generally do it of consent, and there has been no issue hitherto. But
and in fact, that's a better procedure. As Mr. Jeff Palagaratnam says, it is in fact a more convenient and better procedure, more authentic.
Yes.
Yeah, and if you look at it, then you have to go back to the fundamental principles. The Court of the Labor Tribunal is a just and equitable tribunal. It can adopt its own procedures. There are certain basic regulations.
That's right.
And they can say, well, I have a practical difficulty. I can't bring hundreds of people from abroad to my tribunal. So I'm saying, get them on the video, get them on the link, and they are in my presence. I'll conduct the proceedings. So how can you challenge that
procedure?
Yeah. Thank you, sir. I think we have exceeded the time by 20 minutes. And thank you very much, sir. And it has been a pleasure to moderate this. And thank you very much, Mr. Ikram Mohammed, President's Council, Mr. Alagaratnam, President's Council, Mr. Lanka Tilaka, President's Council, for their part, not only for the today's webinar, but their part for having this, preparing this act, the concept, basic concept at the initial stage as well.
Just
thank you very much.
Conclude, Jeff, Section 2 of the Judicature Act.
Yes.
The Court of First Instance for the administrative justice sets out High Court, District Courts, Primary Court, Magistrate Court, Primary Court, and Family Courts.
Yes.
So, on the basis of this Courts of First Instance, perhaps from that concept is tribunals are excluded. Although
on that concept, on the strict technical concept, yes. But I would say that they are more flexible, and I will argue for the view that they should be treated like a court of first instance.
Right.
I would argue for that view.
Thank you very much, sir.
Thank you.
Thank you very much, and thank you for all the participants for being with us for more than 1.5 hours. Thank you very much.
Thank you.
Thank you very much.
Good night, everyone. Good night.
God bless.
Good night.
Good night.
Good night.